Hey, good morning. Looks like everyone is here and we are ready to get started. I'm going to go over a few introductory items and then we'll move on to your presentations. As everyone is aware, these proceedings are going to be live streamed to the public, and I believe we've already started the live stream. So please make sure to silence your cell phones and laptop keyboards. You can press F1 on your keyboard to do that. Good morning and welcome to the Office of Tax Appeals. We are here today in the appeal of George Mays, OTA case number 2408-17038. I am Judge Natasha Ralston and I'm the lead judge on this panel. Also on this panel with me are Hearing Officer Elsom and Judge Brown. We also have our hearing reporter, Ms. Alonzo, who is present and is reporting this hearing verbatim. To ensure that we have an accurate record, we ask that each person speak one at a time and avoid speaking over one another. Even if you think you know what the person is going to say, please let them finish their questions so that we get a clear record. Also speak clearly and loudly. When needed, Ms. Alonzo or any other panel members may interject to ensure that we get a proper transcription. After the hearing, Ms. Alonzo will produce the official hearing transcript, which will be available on the Office of Tax Appeals website. The Office of Tax Appeals is not a court, but is an independent appeals body, which is staffed by subject matter experts and is independent of any tax agency. Okay, does anyone have any questions before we go on the record? Looks like there's no questions. Okay, is everyone ready to proceed? Again, everyone's nodding, so let's move on. Okay. We are now on the record in the case of G. Mays 2408-17038. The date is January 21st, 2026, and the time is approximately 9:37 a.m. This hearing is being held electronically with the agreement of the parties. I am Judge Ralston. I will be the lead ALJ in this appeal for the purposes of conducting this hearing. Although I am the lead ALJ, any member of this panel may ask questions and we will all meet after the hearing to produce the written decision. My co-panelists are Hearing Officer Elsom and Judge Brown. So I'm going to ask the parties to please introduce themselves and who they represent, starting with the appellant. There you go.
Yeah, good. My name is Alla Ratinets. I'm a CPA and I represent George Mays.
Thank you.
Taxpayer.
Thank you. And for FTB?
Good morning. My name is Shaw Khan. I'll be representing Franchise Tax Board.
Good morning. My name is Brad Catino, and I'm also representing Franchise Tax Board in this matter.
All right, thank you. So we held the pre-hearing conference in this case on December 18th, 2025. As stated in the minutes and order, there's only one issue to be decided in this appeal, and that is whether appellant's claim for refund for the 2019 tax year was filed before the statute of limitations. Ms. Ratignolle, do you agree that that's the issue?
Yes.
Thank you. And Mr. Khan, do you agree that that's the issue?
I also agree that is the issue, yes.
Thank you. So the respondent submitted exhibits A through C. And Ms. Ratignolle, did you receive respondents' exhibits and did you have any objections to them?
No, no objections.
Okay, thank you. And for the appellant's exhibits, I know that you submitted the affidavit signed by Mr. Mays. Did you intend to submit that as an exhibit?
Yes.
Okay.
That was submitted as an exhibit, no?
Okay, yeah, well, we'll see now. Let me see. Mr. Khan, did you receive the declaration?
Yes, FTB received that declaration.
Okay, and did you have any objections?
No objection to that submission.
Okay, so we will admit that the affidavit as appellant's exhibit 1. And so, okay, thank you. And is that, did you have any other exhibits, Ms. Retignette, or just the affidavit?
Just the affidavit. Oh, and the proof of attempt to e-file the return and the rejection. That
Okay,
was submitted as well.
was that,
Should be for,
that was submitted with your opening brief or,
was it affidavit and,
okay. And,
was the appeal request.
okay,
Mm.
and I'm sorry, what, can you repeat what those documents were again?
That was the, it's an activity report indicating the attempt to e-file
Okay,
the tax return and the rejection
okay,
due to the lack of PIN number. I guess it was
okay. Mr. Khan, did you receive those documents also?
Yes, that's part of appellant's opening brief, page 10 and 11.
Okay,
So we have those, yes.
okay, and so did you have any objections to admitting those as exhibits?
No objections.
Okay, so for the appellant's exhibit, we will we have the affidavit as exhibit 1, and we'll have the activity report as exhibit 2, and the rejection as exhibit 3, and those 3 exhibits are admitted without objection. Okay, so let's move on. I believe neither party intends to call any witnesses. Is that still correct?
yes, Sharon.
Thank you. And Mr. Khan, no exhibits, sorry, no witnesses, Mr. Khan.
That's correct. No witnesses from FTB.
Thank you. Okay, moving on to the presentations. Appellant has requested 30 minutes for your presentation, and Mr. Khan, you have requested 15 minutes for your presentation. So we'll begin with Ms. Retignette. You have 30 minutes, and you may begin when you are ready.
Okay, thank you, Anna. I will need a lot less than that, but so this appeal must be evaluated in the context of the COVID public health emergency, and taxpayers' contemporaries' efforts to comply. The issue here is whether the a claim for refund was filed timely. Before the statute of limitation expired, the taxpayer attempted to electronically file the 2019 California tax return. That attempt was rejected. The significance of that fact is that the return was prepared, finalized, and available before the deadline. After the rejection, the taxpayer acted promptly and mailed a paper return on June 25th, 2021, as stated in his sworn declaration under penalty of perjury. June 2021 was not a normal filing environment. Government agencies continued to operate under the emergency protocols. Mail delays were widely acknowledged, and the public was advised to limit in-person activities, including visits to post office. Under these circumstances, many taxpayers, including our client, relied on ordinary mail rather than certified mailing. In addition, certified mailing is a safe harbor. It's not a legal requirement. The taxpayer's sworn declaration is a direct evidence of mailing. FTB offers no evidence that the return was not mailed, only that it does not have a record of receiving the return, which is fully consistent with what was happening during COVID with the mail disruptions. Importantly, the return was accepted as filed. The FTB does not dispute that the tax was overpaid. And denying refund does not further the purpose of the statute of limitation. It results in the state retaining funds that it's really not entitled to. The taxpayer prepared the return on time, attempted to file electronically, acted diligently after the rejection, responded to notices timely. In light of those extraordinary circumstances, we respectfully request that the claim be deemed timely filed and the overpayment released. And it's basically the only issue that we have. Thank you.
Thank you. Does that conclude your presentation?
It does.
Okay, thank you. I don't think I have questions for you at this point. I'm going to check with my co-panelist. Hearing Officer Elsom, did you have any questions for the appellant?
Yes, I did have one or a couple questions, Ms. Retania. And first, can you clarify, is this activity report from a tax preparation software, or can you just explain what the activity report is from?
Yes, it is it's from the tax software that we use. It's called Lacert. It's widely used tax software. And the electronic filing is initiated in our office with, using that software, and it goes directly to the government agencies.
Okay, thank you. And then the second question would be, is it looks like you attempted to file the federal return after it was initially rejected and were successful on July 12th, 2021. And I was wondering if you can explain why you or the appellant mailed a paper return on June 25th prior to that. Why didn't you just complete the entire process electronically, considering you had the federal
Because
issue?
California, I'm sorry, I didn't mean to interrupt.
No, that's okay. Go ahead.
It appeared that California rejected it again. So we were not able to do it. And because we knew that it was also mailed on paper.
Okay.
We didn't want a
somewhere-
duplication.
Okay. Is there on the exhibit, can you show me where California rejected it again, or can you just, is there anything you can direct us to?
On 11/21. Oh, on 2/15. On February 15, 2021. Oh, that's
Yeah.
the first transmission.
Mhm.
I may not have that.
Okay.
Oh, I'm sorry. I apologize. That was federal extension that was accepted. It wasn't a tax return, it was accepted by federal government. I'm sorry, I wasn't reading it
Okay.
correctly. So if you look down, it says US past validation, the federal activity, then there's on the bottom of the page, it says federal extension and says US accepted 7/12. That's acceptance of the extension, not acceptance of the tax return.
Okay. Thank you for clarifying.
Yeah.
I
sorry,
had no further
I wasn't
questions.
reading, yeah.
It's okay. Thank you.
And Judge Brown, did you have any questions for the appellant?
I may just have one. If I could ask about do you know what the meaning is of the failed transmission on 11/21 that's reflected in the activity report?
On 11/21.
Where it says 215 sent to the IRS, 215 failed transmission 11/21.
I'm not
Sorry,
yeah,
go
I
ahead.
see what you're referring to. I'm not sure what that means. Sometimes I'd have to go back to our record. Sometimes it means that in November, a lot of times the government closes the filing season. We may have attempted it several times, and if we attempted it during the blackout period that Franchise Tax Board and IRS have between November and beginning of January, every year it's a different date. That would cause failed transmission. Failed transmission could also be caused by if tax return has already been processed and acknowledged as receipt by the government, would get a failed transmission because it wouldn't take the duplicate return. I am not sure what exactly the cause of this failed transmission is.
So it may have just been an automatic.
It may have been that we were just
computer.
attempting to try, they may have made more than one attempt to
Okay.
get it filed electronically because of the mail disruptions, we were very cognizant of that, and we were trying to electronically file as many returns as possible because we did not want to, rely on the mail, especially at that time.
Okay, thank you very much. That's all I have right now.
Okay, thank you, Judge Brown. We are going to move on to respondent's presentation. Mr. Khan, you have 15 minutes for your presentation. Please begin when you are ready.
Thank you. Good morning. My name is Shaw Khan. I'm a program specialist too at the Franchise Tax Board. Along with me is counsel Brad Catino, and we will be representing the Franchise Tax Board, or FTB, in this matter. As mentioned earlier, there's only one issue in this appeal, and that issue is for the 2019 taxable year. The appellants did not file a claim for refund prior to the expiration of the statute of limitations. Under California law, there are multiple avenues for taxpayers to seek a claim for a refund. However, there are strict time limits associated with these avenues. The California statute of limitations generally has limitation periods, and taxpayers can utilize it generally has 3 limitation periods, and taxpayers can utilize the latest date allowed by these 3 limitation periods to file a claim. The first limitation period provides that taxpayers can file a claim for refund 4 years from the date a return was filed if it was filed during the extension due date period. The second limitation provides that taxpayers can file a claim for refund 4 years from the original due date. And finally, the last limitation provides that states that taxpayers can file a claim for refund 1 year from the date of overpayment. The law does not provide for the waiver or of the statutory period based on reasonable cause or extenuating circumstances. In this case, FTB has no record that the appellant completed a timely filing of their 2019 return. There was, as mentioned, an electronic attempt to file a 2019 return in February 2021. However, this electronic return submission was rejected. Because this return was rejected, appellant alleges that they sent in a paper return shortly after the 2021 rejection. However, FTB has no record of this 2021 submission. FTB's records show that the first return received and processed for appellant was in May of 2024. And because of this, only 2 of the 3 general limitation periods are available to the appellant. The appellant could timely file a claim for refund under the limitation periods, which allows a taxpayer to file a claim for refund within 4 years from the original due date of the return, which was April 15, 2024. Or the appellant could timely file a claim under the limitation period that allows appellants to file a claim for refund 1 year from the date of the overpayment. The appellant's May 2024 submission is the first and only process return that FTB has on file, and this filing was beyond the 4-year time allowed, and thus FTB correctly disallowed the claim under the 4-year statute of limitations. If the 4-year statute of limitation has run, only payments made within 1 year from the date of overpayment can be refunded or credited under California law. Withholding payments, which make up the totality of the refund claim, are deemed paid on the return filing due date of April 15, 2020. Therefore, the withholding payments are also barred by the 1-year statute of limitation. Lastly, I want to address the additional briefing, which included an affidavit that was submitted as part of the additional briefing. In the Office of Tax Appeal precedential case, Appeal of Fisher, that was cited in FTB's additional brief, it was decided that taxpayers attempting to prove that a paper return was timely mailed would have to show evidence, such as a registered or certified mail receipt, showing that the return was timely mailed and filed with FTB. To date, FTB has not received evidence of a registered or certified mail receipt from appellant, and accordingly, FTB's denial of appellant's claim for refund is proper and should be sustained. I'm happy to answer any questions you may have or provide any clarification regarding FTB's position. Thank you.
Thank you, Mr. Khan. Does that conclude your presentation?
It does. Thank you.
Thank you. I believe Hearing Officer Elsom, did you have any questions for the respondent?
Hi, Mr. Khan. I did have one question for the Franchise Tax Board, and that would be, is there any information in lieu of a certified or registered mailed receipt that the Franchise Tax Board would accept to prove as proof of the filing date that appellant asserts?
Yes, we have in previous cases looked at situations where a sworn affidavit by someone that's not the appellant can provide a statement that says that a return was mailed. So something equivalent to that. We would even consider other form of contemporaneous documentation that timestamps that this return was attempted to be mailed or sent that date.
Okay, thank you, Mr. Khan.
So Ms. Retinyet, you heard Mr. Khan's statement that there's other documents that FTB would accept. Do you have any of these other documents that you could provide, some other contemporaneous documentations, or is there like another party other than the appellant that could submit an affidavit? Anything like that? Oh, Ms. Retinyet, you are muted.
Sorry, apologize. Considering that it was mailed regular mail, there is nothing that, taxpayer or us can provide that would show the attempt, to mail the return. I do have a question. In 2020, there was a postponement, and I believe the due date was not April of 2020 for 2019 tax return, but it was either October or November of 2020 due to COVID. And Franchise Tax Board, it was, issued that pronouncement, I think sometime in 2020. So the original due date and the original payment would not have been considered to be April of 2020, I believe, but rather October or November of 2020. So the 4-year period, I believe, should start, or, the payment should be considered to be paid on that date as opposed to April of 2020. But that makes it, that's just a comment on my part.
Okay, thank you. Judge Brown, did you have any questions for Mr. Khan?
I don't think I have any questions. Thank you.
Okay, thank you. So, Ms. Retinyet, did you want to give a rebuttal to respondent's statement?
Look, my major point is that the circumstances during that period were not ordinary, and the requirement or the government limited or suggested limiting access of citizens to public places, including post office. There was really not a lot of options for the taxpayer to send the tax return if it didn't go through electronically other than regular mail. So it was the only way at that particular time during that very extraordinary time that the taxpayer could comply with the filing requirement. And that's just the matter of fact,
Okay,
That's
thank
all I
you
have.
very much. Thank you. Let's see, I'm going to check with my co-panelist again just to see if there's any final questions for either party. Hearing Officer Elsom, did you have any final questions?
I do not have any additional questions. Thank you.
Thank you. And Judge Brown, did you have any final questions for either party?
No, I do not have any additional questions. Thank you.
Thank you. I think as well, all my questions have been answered by your presentation, so I appreciate that. There, it looks like we are ready to conclude this hearing. So this case is submitted on January 21st, 2026, and the record is now closed. The judges will meet and deliberate and decide your case, and then we will issue a written opinion within 100 days. OTA is in recess and the next hearing will begin